follows our domestic courts on hearsay rules. But a lot of times evidence you might have against an alien combatant, it would be difficult, for example, to require a soldier who's out on the battlefield to come back to wherever this court is and provide testimony. I mean, it would interrupt his performance of his battlefield duties. That would be one example. Another thing is, it wouldn't be reasonable to expect that in a battlefield setting you would give Miranda warnings to captured detainees, as you would expect if we were to arrest a soldier under the UCMJ. Chain of custody is another issue. I mean, in a typical criminal trial, you would imagine, any piece of evidence is being authenticated. It will go through all of the places this evidence was held to be sure that it had never been tampered with. Again, that kind of authentication is not something that's practical to expect to do in a battlefield. I mean, we can't expect that our soldiers who are conducting combat operations have to stop their combat operation, pull out a sealed bag, put the evidence in the bag, put it in the particular location, and then testify about everywhere where that evidence has been. So I think it's in recognition of some of these differences in situations that the decision was made to move away from courts-martial to military commissions. Last point on this, though, is that if you actually look at the court-martial rules and you look at the rules for military commissions, they're very similar. So there are a few differences, but they are by and large similar rules.
Can I just address that for a second? Because one of the differences that Vijay didn't allude to, and that I think was one of the driving forces here, is that physically coerced testimony would not be admissible against a U.S. serviceman in the UCMJ tribunal, and yet they, in the MCA, they specifically carved out a possibility for the government to use coerced testimony as long as the judge finds it's reliable against these individuals. And I think that's an example of the government making the wrong decision initially to use coerced testimony, to coercive interrogation tactics, then leading them into this corner where they couldn't accept procedures that we accept for our own soldiers because we made that, we sort of engaged in that initial original sin of coercing the testimony in the first place. And I think that's a driving force. I agree with Vijay that there are other differences like Miranda rights, but it seems that's not really central. What is central is the fact that against so many of these people, the testimony is coerced, particularly the high-value people, and the government, doesn't know, what to do with them if it can't use that coerced testimony.
Can I just respond to that? I just want to it should be important to note a couple things. One is that no torture obtained evidence is admissible in a military commission. No evidence that was obtained in violation of the Detainee Treatment Act is admissible in a military commission. And the last point is, I think what we've already seen from the performances of the judges, the military judges that are there, is that they are not going to accept into evidence items that are derived from techniques that you would consider shocking the conscience. I mean, I think the performance of the military judges in the system is a very good check against the kind of concerns David is raising.
Let's hope so.
Yes, Betsy?
I want to ask a question about the two cases together, because I, at least listening to David's presentation and Catherine's presentation, I'm struck by an irony. On the one hand, David described a court that is, and like courts in other countries, maybe reaching out, articulating or extending a right, a habeas right in a new context, flexing its muscles vis-a-vis the other branches. On the other hand, Catherine describes a court that is, I think, rather timid, where you've got the political branches or the executive agreeing, the court agrees there is an obligation here, yet the court is being timid in its enforcement and implementation of that obligation. How do you square that? Is it, make sense of that for me?
I'll just start, and people, of course, might have different views on this, but I think it's always a hazardous endeavor to try to figure out what's in the mind of Supreme Court justices. And the cases we talk about are difficult cases, and oftentimes they're 5-4 or 6-3, and we're trying to figure out what's going inside the mind of Justice Kennedy or another justice, and it's very difficult to say what's motivating him. I mean, one possible way to reconcile it on the 200,000 feet above sea level approach is that in both these cases, the Supreme Court is saying, we don't like it when other people are telling us what to do. Whether it's a foreign court or the president or Congress, we just don't like it. Now, I'm not going to say that's what's motivating Justice Kennedy because I don't know what's inside of his head, but you asked the question, so that's my best answer.
Yeah, just very briefly. I think that again, we're all reading tea leaves here, but I think that that thread is precisely the right thing that may be motivating this court, because it was clear from oral argument, as I mentioned, this is a court that did not like the notion that they had no wiggle room, that the ICJ had rendered a judgment, and that was the judgment, that it had to stick, notwithstanding the contrary interpretation in Sanchez-Llamas. And I think my point is just that, yes, that could be a reaction, but institutionally, if you look at the role of the Supreme Court going back 200 years and under the Constitution to tell us what federal law is, that's actually, ironically, a step backward.
And I'll just take another stab. I think, although John may be right about the court's own notion about its own power and the right of others to tell it what to do, I think also there's something of a distinction between enforcing international law of its own accord, which the court has always been somewhat, well, at least in the modern era, been somewhat reluctant to do and ambivalent about, and international law as gestalt, which is really what I'm talking about. I mean, there wasn't an international law issue really in the Boumediene case. It was a question about whether U.S. domestic law applied across our borders, but it was about U.S. domestic law of its own force. And I think the international developments that I alluded to operate at the level of gestalt much more than at the level of sort of doctrinal, substantive law operating of its own accord.
Yes, in the room.
Question for BJ. You may distinguish between the Guantanamo holding facilities in the hot zones in Iraq and Afghanistan. Would it be an acceptable solution for the administration to transfer these detainees back into the hot zone?
No, that wasn't what I was trying to suggest. I think what I was trying to suggest was that when you are holding detainees in a hot combat zone, it would be very difficult to bring in habeas corpus proceedings with all of the evidentiary hearings and so forth that are being contemplated in the Boumediene decision. I don't presume to speak for administration policy in terms of what exactly is done, but I don't think it would be considered that you would move individuals back into a hot combat zone in response to the decision.
Other questions? Yes, sir.
About 3 years ago, the United States filed in opposition to a petition by Iran. That case involved rights asserted by a U.S. company that protected its investment in Iran. And in the United States declared that it did not believe that these investment protection provisions were intended to be enforced in the U.S. court by a U.S. person. And the majority said something to the effect that in order for a treaty to be enforceable by a U.S. person, not only does the treaty have to be self-executing, but there needs to be some words in the treaty that the treaty is to be enforced in the U.S. court. I'm curious to know whether any of the panel members kinds of words might be needed.
Yeah, if I could, I think the first place you start, this is one of those situations where you start with your remedy and work your way backwards. And I think that's what the court did. In distinguishing, for instance, the average bilateral investment treaty or multilateral investment treaty, what's critical is when there's